what I'm going to be doing here is going over the Dallas County orders related to the COVID-19 epidemic and whether I think they're legal. The orders can be found at the dallascounty.org website at this hyperlink here. What I'm going to do is start with the history of how we got to the current stay-at-home orders. On March 12, 2020, there was a declaration of a local disaster by County Judge Clay Jenkins related to COVID-19. Now, even though he's called a judge, he isn't really a judge. He's the equivalent of the mayor of Dallas County or the chief executive officer. And this was issued pursuant to Texas Government Code Section 418.108. And this declaration would last for 7 days, which is the maximum he can issue a disaster declaration for without ratification from the Dallas County Commissioner's Court, which is like the legislative body for Dallas County. And this can be found at this URL here. The statutory authority in Texas law, as I said, is Chapter 418 of the Texas Government Code. And once the disaster was declared, the county judge had certain powers. And I've put the text of the most relevant aspects of that statute here. So for instance, at 418.108F, he can order the evacuation of all or part of the population if he determines that the action is necessary for the preservation of life or other disaster mitigation. Probably what's being acted pursuant to here is this 418.108G, in which the county judge can control the ingress to and egress from a disaster area, which would be Dallas County, and control the movement of persons and the occupancy of premises in that area. And once again, here I've simply laid out some of the more relevant language that I think is being operated under by the county judge under 418.108F. But does this language actually give the county judge and the county commissioners the authority to issue a stay-at-home order like they've issued? For instance, what is meant by the movement of persons? This sounds more to me like the movement of persons for things like directing traffic. For instance, if there's flooding, could the county judge order people to leave their homes, for instance, and reside at American Airlines Arena based on this? I doubt it. What is meant by the occupancy of premises? To me, this sounds more like stopping people from squatting in unoccupied structures or structures damaged during a hurricane or a tornado. And by just the plain reading of the statute, the county judge can prevent people from leaving Dallas County. But I have a hard time believing that he has the constitutional or legal authority to actually do that. What are the limits to this power? Now, after declaring Dallas County a disaster area, he then issued an order prohibiting community gatherings. And this was defined as 500 or more people in a single room, or they're single confined or enclosed space, such as an auditorium, theater, stadium, et cetera, et cetera. I've put the language here. And the order was put together a little bit sloppily because it says under the authority of Texas Government Code Section 108. Well, there is no Texas Government Code Section 108. I think what was meant is Texas Government Code Section 418.108. It's just not entirely clear from the document. It wasn't artfully written. And there's the URL for it. Then on March 16th, Judge Jenkins closed bars and restaurants in Dallas County. The community gatherings limit was reduced to 50 or fewer people and was defined to include gyms, theaters, and meeting halls. Restaurants could only do takeout. Bars, arcades, and private clubs were ordered closed, but bus stations, airline terminals, grocery stores, office space, shopping malls, and other retail establishments were exempted. If someone In a household tested positive for coronavirus, they were ordered to isolate at home, and all of the members of their family were also ordered to isolate. Once again, you can find that URL for that order there. On March 18th, an amended order was issued. This order prohibited social gatherings, which it refers to at points as recreational gatherings, and at other points as social gatherings. It's not entirely clear. It says social gatherings is defined in Section 3, but it isn't, just recreational gathering. And it gives a list of examples of social gatherings, including parties, backyard barbecues, et cetera, et cetera. And it exempted the following so long as visitors are generally not within 6 feet of one another for extended periods. So airports, bus stations, government buildings, schools, office buildings, grocery stores and pharmacies, hospitals. The order also advised that justices of the peace should suspend eviction hearings and writs of possession for at least 60 days. And I don't see how this could at all possibly be legal. There's no authority under Texas Government Code Section 418.108 to allow this. And I think it would be a taking of property without due process of law under the 14th and 5th Amendments to the US Constitution. And that's probably why it's advisory, because I don't think they have the authority to actually do that. You can find the URL here. March 21st, 2020, another order is issued. And this order closed things like spas, tattoo parlors, and beauty salons. Also included martial arts studios and gymnastic studios as in the definition of gyms. The big one was all, quote, elective medical, surgical, and dental procedures were prohibited anywhere in Dallas County, but it left up to hospitals and medical facilities to determine what's, quote, elective. And the language regarding that is here. I'm sorry. Well, yeah, it is. That is the language from the actual order right there. And you can find that that URL if you're interested in seeing it yourself. On March 24th, 2020, Clay Jenkins issued a shelter-in-place order. And I couldn't find that order, the PDF version, on the website. There's a link to the Spanish version, which is here. Well, the Spanish version link would be here. But the summary on the website says all individuals currently living within Dallas County are ordered to shelter at their place of residence as of March 23rd, 2020 at 9:00 p.m. And businesses that are not essential were ordered to cease activity, although employees could still work from home. On March 29th, 2020, Clay Jenkins issued an amended stay home, stay safe order. And it order says that people are to shelter at their place of residence and may leave their residence only for essential activities or to provide or perform essential government functions to operate essential businesses. All businesses operating within Dallas County except essential businesses were required to cease activities except for minimum basic operations, and that's defined in the order. Employees could continue to work from home, and all public or private gatherings of any number of people occurring outside a single household were prohibited, except as otherwise provided in the order. And you can find the full text of the order at this URL. A big one, or a big part of that order is the March 29th, 2020 order imposes criminal penalties or alleges to impose criminal penalties for those who violate it. And it says that a violation is punishable by a fine not to exceed $1,000 and or confinement in jail for a term not to exceed 180 days. Once again, you can find that order at this URL. Now, what is the statutory authority for the penalty violation? You know, presumably, it's Texas Government Code Section 418.173, which does allow for a fine of $1,000 or a confinement in jail for up to 180 days. And that's the only section of Chapter 418 that I could find that dealt with penalties of any kind. But does this provision actually confer the power on the county to impose the penalty? It's not at all clear to me that this is authority to do what was done in the March 29th, 2020 order. The context of the language seems to speak of failure to comply with the plan or with a rule, order, or ordinance adopted under the plan. So what is the plan? What is this emergency management plan? And where is this emergency management plan? I can't find it anywhere on the internet. I'm not saying it doesn't exist, but I simply don't see it. Does this imposition of the penalty comport with procedural due process? And I'll talk more about that later in terms of what is procedural due process, but it's a constitutional concept or concept from constitutional law. Even when a criminal statute is enacted by the legislature, you have to provide people with certain due process in the sense that the legislature has to adopt it. And it has to be approved by the governor, signed by the governor. Can the legislature of Texas delegate that authority to impose criminal penalties like this to Judge Jenkins and the Dallas Commissioner's Court? I seriously doubt it, but this is just my best educated guess. I searched the internet for Texas Emergency Management Plan, and what I found was the following, which is found at this, looks like some kind of website for Association of Texas Counties. And it says the county may enforce a penalty of a fine not to exceed $1,000 or confinement in jail for a term not to exceed 180 days, et cetera. That same language. It notes 418.173. But then in that same document, it says, if the county wants the ability to enforce this penalty, its emergency management plan should provide that a failure to comply with the plan or rule or order adopted under the plan is punishable as authorized in Government Code Section 418.173. So once again, where is this emergency management plan that Dallas County has implemented? I don't know. And I don't think the order of the county judge itself is this, quote, emergency management plan. So the constitutional problems I see with the Dallas County stay-at-home order are basically in three areas. One, the constitutional right to travel. Two, the 14th Amendment due process rights. And three, right to freedom of assembly. Constitutional right to travel is summed up well in a case called Sanchez v. Roe, which is in front of the U.S. Supreme Court in 1999. And it says there are three different components to the right to travel. I've laid them out here. The first is the right of a citizen of one state to enter and leave and to leave another state. The second is the right to be treated as a welcome visitor rather than an unfriendly alien when temporarily present in the second state. And the third is for those travelers who elect to become permanent residents, the right to be treated like other citizens of that state. Additionally, I think the other problem with these orders is under the 14th Amendment, which basically says that you can't be deprived of liberty without due process of law. Now, this includes both a substantive right to liberty as well as a procedural due process right, a right not to be deprived of liberty without, quote, due process. So even when the government can rightly deprive someone of life, liberty, or property, it can only do so if that person is afforded a certain process. A county judge's quarantine order would probably affect liberty interests to which process is due. Now, what is liberty such that process is due? Well, there are basically three ways that liberty can be impinged upon. The first would be like a physical restraint by government action, such as prohibitions on action or movement, putting someone in jail, ordering them to stay in a particular location or at their home. The next area would be governmental denial of the exercise of special constitutional rights, for instance, First Amendment rights, freedom of assembly or speech. The third would be government denial of, quote, other rights or liberties. An example of that would be this case I've cited here, Wisconsin v. Constantino. And it was a U.S. Supreme Court case in which a sheriff basically issued a notice that someone was a drunkard and posted it at all the bars and liquor stores, and it prohibited that person under Wisconsin law from buying alcoholic beverages. And that was considered a violation of a liberty right without due process of law. Now, what process is due if a governmental action deprives someone of liberty or property or life? First, they're entitled to notice of the charge or issue. Second, they're entitled to an impartial decision maker before their liberty is deprived. And third, they're entitled to opportunity for meaningful hearing. Now, what about mass deprivations of liberty or property or life? So if the government deprives a large number of people of liberty, does that somehow affect the analysis? Now, when the legislature imposes a new law, it can affect the liberty of all. But people are still entitled to due process, but in that specific circumstance, they're entitled to the due process that would be afforded them under, for instance, the state constitution, that would be both passed by both chambers of the legislature, that would be presented to the governor, that would be signed by the governor, et cetera. That's the due process that would be involved if you have a law of general application that impinges on the liberty of all people. And I've cited it to a practice guide here that notes that procedural due process issues arise when an individual or group is claiming a right to a fair process in connection with their suffering, a deprivation of life, liberty, or property. So procedural due process arises when an individual or group is claiming a right to fair process. So let's turn to the case law on mass quarantines. There isn't a lot of case law on this. The first one I found that's fairly old is Juho v. Williamson. At this point, it's 120 years old. The entire Chinatown area of San Francisco was quarantined due to fear of bubonic plague, even though many people in that quarantine zone did not have bubonic plague. And the court in that case said that this illegally discriminated against Chinese in violation of the Equal Protection Clause of the 14th Amendment. And it also said that the quarantine of a large portion of the city, which included large numbers of uninfected people, was not consistent with the state's, quote, police power. And the police power is basically the authority of the state to enact laws to protect the life, liberty, and safety and health of the citizens. Now, this is just a district court case in California, the Northern District of California, but it's still, at least in that area, would be considered controlling, and other areas it would be considered persuasive, perhaps. The next case that I found is Jacobson v. Massachusetts. This is a US Supreme Court case from 1905, and it was a challenge of a local ordinance requiring vaccination of all adults over 21 for smallpox. The court said that this was constitutional, but some interesting language that was found there included the court saying that it might be a particular exercise of the police power might be exercised in a manner that was arbitrary or unreasonable, and goes so far beyond the bounds, beyond what was reasonably required for the safety of the public, as to authorize or compel the courts to interfere with the protection of such persons. And this is an actual quote from the case. The next case is Vitek v. Jones, also a US Supreme Court case from 1980. It involved a prisoner in prison who was transferred to a mental hospital, and he made a procedural due process challenge. And he said that he needed notice and an adversary hearing before an independent decision maker, and a written statement by the fact finder, and also to the appointed counsel before he could be transferred to the mental hospital. And the court did say that he had due process rights regarding involuntary commitment, even though he was a convicted felon. And this was an interesting quote, I thought, from the case. The medical nature of the inquiry, however, does not justify dispensing with due process requirements. It is precisely the subtleties and nuances of psychiatric diagnoses that justify the requirement of adversary hearings. I think you could analogize this to depriving people of liberty because they may or may not have a communicable disease. So I think this is applicable. The next case I found is Jihad v. Wright, which is just a district court, a trial court, although federal, in Indiana. This was in 1996. It involved a prisoner who refused to take a tuberculosis test that would involve an injection. The court, amongst other things, said that the prisoner's 14th Amendment right to due process was violated. And they basically had problems with the fact that he was put away with other prisoners who did have tuberculosis without any kind of determination that he actually had a communicable disease. So once again, this was a procedural due process violation. He had no hearing, he had no notice, he had no counsel, and he was simply put away with other people who had tuberculosis, even though it was never established that he in fact had tuberculosis. The last case that I came upon was Hickox v. Christie, which is recent, and this involved the Ebola epidemic, and this is the federal district court in New Jersey. And a nurse said that her 80-hour quarantine upon returning from Africa violated her 4th and 14th Amendments rights. The state was granted a motion to dismiss on something called qualified immunity, which for purposes here, it just means that she couldn't obtain money damages because she'd already been released from quarantine, and the state officials were not found to have acted in a way that was so unreasonable that they should have their immunity stripped from them. It didn't really address whether a person could seek an injunction if they were still under quarantine. So, you know, this case, don't assume that just because this case says she couldn't win on her 14th Amendment violation, that someone who was currently under quarantine, the result for them might be different. And this case had a really interesting quote, I thought, and it referenced Juho v. Williamson, that California court case that we discussed earlier. Basically, it said such an overbroad order, in such an overbroad order like the Juho case, the court declared was not in harmony with the declared purpose of preventing the spread of disease. In other words, it was so overbroad that it didn't meet the purposes that the state officials were articulating for having the order. Now, here are the specific issues that I think I see with the Dallas County COVID-19 stay-at-home orders. And this is just my best legal guess. I could be wrong, but this is the way I see it. It's a quarantine of the entire county, which includes many people who are not sick. So per Jacobson v. Massachusetts, it goes so far beyond what was reasonably required for the safety of the public as to authorize or compel the courts to interfere with the protection of such persons, for the protection of such persons. So in other words, federal court can come in and act to protect people who've been ordered to stay in their homes by Dallas County despite the fact that they're not sick and that there's been no evidence that these particular people are sick. Per Hickox v. Christie, assuming that that case is persuasive, and Juho v. Williams, and assuming that that one is also persuasive, sealing off an entire city to prevent the spread of disease is unreasonable, unjust, and oppressive. It's an overbroad order not in harmony with the declared purpose of preventing the spread of disease. Per Jihad v. Wright, every individual in Dallas County is entitled to a determination of whether they have had an infectious communicable disease before being ordered to stay at home, assuming that you consider Jihad to be persuasive. Per Vitek v. Jones, every single person being ordered to shelter in place in Dallas County is entitled to procedural due process. So they're entitled to notice and a hearing by an impartial decision maker, which no one has received. And that's on an individual basis. I've done an outline of quarantine law in the Constitution. I'll probably be adding to it as time goes by. I've placed it on my blog. Right now, it's the most current entry, but you can find it at this URL here.